All right. Officer Day, would you open my courtroom, please?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We are on the record calling case number 2014890, Affiliated Diagnostics versus City of Detroit. Date and time for pretrial. Your respective appearances.
Good morning, Your Honor. Tricia Nelson, P68707, appearing on behalf of the plaintiff.
Chris Olmstead, P69202, appearing on behalf of the City of Detroit.
It appears that when we were last together, City of Detroit failed to appear.
Yes, sir.
Case, and I was looking, and I entered the default of the city, and then on March 29th, by stipulation, the default was set aside. So, first of all, I want to know if all our discovery is completed now.
Yes, Your Honor, I believe we are. I'm sorry, Ms. Nelson, did you have something to say?
I was just going to say, I know we sent our disclosure, so I believe from our perspective, discovery is done.
Okay, so Ms. Olmstead, you're done as well?
Yeah, I have no other further discovery.
Okay, then why are we killing this file?
We're really just within a few $100 of a difference. We've been discussing. We've gone to a lot of settlement discussions back and forth on this one. So if you want to know the truth, Your Honor, it's difficult with the MRI cases with the city, and I think we're really close. I just sent Ms. Nelson another
a few $100.
I just sent Ms. Nelson another offer. So I'm hoping we can get this one done.
Let's kill the file. You don't think talking about it today will help you?
I'm trying to save the city, Judge.
That's not my question. I'm talking about killing the file.
What was your question, Your Honor? I'm sorry.
I want to know, since you guys are close, whether or not having a talk today could help you kill the file.
Yes, Your Honor. I was asked to be placed into a breakout room. I think we can get it done.
I think I can do that. I'm going to try to do that. Okay, let me make
it.
Doesn't work out. Don't take it personally. All right, breakout room. Okay, so that's going to be Olmstead. Oh, here it is. Okay, Nelson, room 2. Olmstead, room 2. Okay, I think I have sent you guys to a breakout room.
Yes, you did. Thank you, Your Honor.
Okay, let's get this file done. $100, because so ain't worth y'all coming back spending your money. As much as I enjoy talking to you. All right, let's go to who's next. All right, let's see. Ms. Hetty, what brings you here today?
Your Honor, I have a pretrial conference on McCornell. It's case number 21-68561.
And who do you have?
I have USAA, Your Honor.
Okay. And anybody here on that file?
That would be me, Your Honor. I'm representing James McCornell.
Well, then I think I have a pair. Let's get you two on, and let's see if we can't get everybody else off to our waiting room. Mr. Hill, glad that you could join us. And Ms. Easley, we'll get you to hopefully very soon. Okay, so this is 20561. We are on the record. This is case number 201686561. James McCornell versus USAA Casualty. Could I have your respective appearances?
Good morning, Your Honor. James Eccleberry appearing on behalf of Plaintiff James McCornell, P78222.
Good morning, Your Honor. Fiona Hetty appearing on behalf of USAA, P81469.
Okay, and you guys came here to tell me you'd already settled, right?
Wouldn't that be nice, Your Honor?
Wrong answer.
Only, Your Honor.
First of all, let's find out whether everybody's made their 302A disclosures. I got one proof of service from one side. How about the other?
Your Honor, ours were filed on 3/10/21.
All right, so everybody has each other's initial disclosures.
Yes, and we have plaintiffs. Yes, sir.
Yes.
Okay, so what do we need to kill the file?
So, Your Honor, we are requesting discovery in this case. We had communicated with plaintiff's counsel, and it was our understanding that this court required not just a stipulated order. So we waited until today to request this. I don't believe there's any objection from plaintiff for discovery, but we would be looking for very limited written discovery and then the plaintiff's deposition.
Well, let me ask this before we get off into all of that.
Yes, sir.
The vast majority of the information that you would be seeking by interrogatories is part of the disclosure package. That's why they're mandated these days. And what ballpark, don't give me an exact figure, but what ballpark are we talking about in terms of the amount in controversy?
Your Honor, plaintiff's initial disclosures have about $11,000 in outstanding no-fault benefits.
Okay. And what is the nature of these benefits? Are these medical bills, wages, combination, or what?
Combination, Your Honor. There are a couple medical bills that are unpaid. There are some household services that are unpaid, and there is some wage loss that is unpaid. I would note that the carrier had paid for some of each category of benefit in advance of litigation in this matter. So I don't anticipate a dispute as to the rate being demanded, only the reasonable necessity after defendant's cutoff.
Let me ask you this, Ms. Hetty. Your cutoff was based on what? An IME?
Yes, Your Honor.
And were all the benefits claimed prior to the IME paid?
As far as we're concerned, yes, Your Honor.
Tell me what, as far as we're concerned, means.
That there may be some dispute about the rates that were paid, but all the services incurred up to that date, some portion thereof was paid. Yes, sir.
All right, so you're disputing both. All right, well, here's what I'm going to do. Have you had a chance to review each other's initial disclosures?
Yes, Your Honor.
Yes, Your Honor.
Right, okay. What I'm going to do at this point is I'm going to open written discovery only, limited to 20 interrogatories per side. And then we'll see where we're going. I am reluctant to incur well, I don't incur the expense, but to have the parties incur the expenses related to depositions, because by definition, you're here because it's a small file. Otherwise, you wouldn't be in a district court. And when you start spending money for depositions, all of a sudden we get to a point where we run up expenses that interfere with the resolution of the case. And given the reality that we all know that's where we're going, let's not put up unnecessary obstacles in the path that we all know where we're going. So let's get you guys another date. Let's open your written discovery limited to 20 interrogatories each. And then hopefully we'll be able to get the thing done next time we're together. We shouldn't have that much, really, that we have not been able to resolve. I really have found that since I have been mandating these 2.302A disclosures, it's cut down and moved files a lot more rapidly. I don't know why we were excluded from that in the courtroom. I really don't, but I don't make the rules. Does May 25 work for both of you?
Yes, Your Honor.
What about you, Mr. Eccleberry?
Your Honor, I do have a conflict on the 25th.
Okay. Is it a time conflict, or we move you, say, 11 o'clock?
I've currently got a deposition scheduled beginning at 9 that morning.
Oh, okay, so that's not a good date for you.
Yeah.
All right, what about the 26th of May 26th?
That works for defendant, Your Honor.
Mr. Eccleberry?
Looks good, Your Honor.
All right, May 26th at 10 o'clock then will be our next pretrial.
Thank you, Judge.
And what I'll do is in the order scheduling the pretrial, I will indicate the parties may serve no up to 20 interrogatories per party.
Very
Anything else we can accomplish today?
No, Your Honor, just to clarify, no separate order is required from defendant regarding
No,
discovery. Is
no,
that-
what I'm going to do is going to be in the order of adjournment.
Perfect. Thank you, Judge.
What I'm required to do is I'm required to speak by written order, but I can be pretty flexible about where I write it down.
Thank you very much.
Let's get this one done, guys.
Yes, sir.
Okay, thank you both for coming in. We're gonna release you off the record.
Thank you, Your Honor.
Thank you, Judge.
Okay, be safe. Give me just a second to get my paperwork done. All right, let us recall the file Affiliated Diagnostics versus City of Detroit, 2014890. You came back to tell me you settled.
Your Honor, at this point in time, I need to take the new offer to my client. I think we are extremely close now. The increased offer was significant, so I think it will get it done, but I just cannot contact my client right at the moment. So I should be able to hopefully have a response today for Ms. Olmsted.
Okay, then how about I give you a short return date? Does that make sense?
That's fine with me, Your Honor. Yes, Your Honor, it does.
What about Monday, May 10th?
Double checking, but that should be fine with me, Your Honor, depending on the time. Well, I'm open all morning, so
Okay,
any
that's
time is
fine.
fine.
Let's see if it works for Ms. Olmsted.
Yes, Your Honor.
May 10th at 10 o'clock it is. Now, since we're so close,
Okay.
let's get this turkey done.
We would both love to.
We know where we're going, right? Come on. When's the last time either of you tried a 15? Okay, May 10th, 10 o'clock. Let's get this one done, okay?
Done, Your Honor. Thank you.
Thanks, guys. Be
Your
safe.
Honor.
Talk to you May 10th. Good morning. This is case number 21-140-107. The case is entitled General Linen and Supply versus El Panque Mexican Restaurant. This appears to be our initial pretrial, your respective appearances.
Good morning, Your Honor. Ryan Hill on behalf of the defendant, P68445.
Counsel, your appearance?
Morning, Your Honor. This is Molly Eklund Easley. I'm here on case number 20-165479.
Bar number?
P30653.
Okay, we opened your written discovery on this file. Where are we, folks?
Your Honor, I believe the case that you called is not the case that I'm here on.
That's
I was
correct.
simply checking on a,
You're not here on affiliate, oops. Let me see. Why are you here, ma'am?
Your Honor, I'm here because opposing counsel was supposed to have submitted a stipulated order for conditional dismissal.
Oh, you're here on the O'Neill matter.
Correct, Your Honor.
Okay, well, what I did is I got a partial fax of a conditional dismissal. It had the first sheet and half of the page where my signature goes. So what I did is I entered a order dismissing the case without prejudice and noting on the order that the original conditional dismissal was to follow because I had a poor quality fax.
Okay.
Okay? So
All right.
you're all done.
Thank you very much, Your
But
Honor. Have a wonderful day.
What happens, I got the full first page, then I got
Okay.
half of the second page. So
All right.
I can't really enter an order where if nothing else, I don't have all the terms and the signature block is gone.
Right. My understanding is that they mailed it in back on April the 15th.
Well, it might catch up. I don't have that at this time,
Right.
but the case is done. It's just a matter then of the mechanics one way or the other.
Okay.
Okay?
All right. I'll catch up with them.
All
Thank
right.
you, Your Honor.
Have a good day, ma'am.
You too. Bye-bye.
So, Mr. Hill, I don't have your other side as of yet.
Do you want to wait till 10:30, Judge, or what do you do?
I wait till 10:31.
Okay.
Then we'll have a resolved case one way or the other.
Thanks, Judge.
All right, I'll get back to you, put you in the waiting room, okay? All right, waiting room. And we'll go offline. Okay, so all these things. Ah. Mr. Hills is gonna be a dismissal. All right. Ma'am, why are you here? Ma'am? Why are you here?
Judge, I have Judge Coleman calling me on another case. Can I, 1 second?
Please. Ma'am, why are you here?
Am I too early?
What is your name, ma'am?
My name is Danita McQueen.
Danita McQueen?
Yes.
Are you due today?
Yes. It says April 27th at 11 though. I'm sorry, I'm 30 minutes early.
Okay, you sure that case, what's your case number, ma'am?
Case number is 20156-539.
All right, hang on just a second. Give me your case number one more time.
20156
156
539. I'm sorry.
539.
Yes.
Okay, that case, I don't believe is still up. I think Danita McQueen. Okay, let me put you on the waiting room and let me check with my clerk because I don't see that on my docket for today.
Oh, okay.
Hang on.
Okay.
District Court. Can I help you?
Carrie, this is a judge. Can you look up a case for me today, please?
In civil?
Yeah, I think
Okay,
20156-539. She said she's due today, but I don't see it on the docket.
it does say 11 o'clock today for a motion schedule.
Okay.
Let me look for it and I'll call you back.
Oh, no, I have a file here.
Oh, you do?
Yeah. Okay.
Yeah, it's a motion scheduled for today, 11 o'clock.
All right. Thank you.
Okay, you're welcome.
Bye-bye. Ms. McQueen,
Yes.
I have you checked in for the 11 o'clock, okay?
11. Okay, 11 o'clock. Okay, thank you.
Okay. You want to go in the waiting room or you want to come back?
I can come back.
Okay.
Okay, thank you.
But I'll just hang up and we'll come back at 11.
Okay, gotcha.
Thank you.
You're welcome.
Mr. Hill?
Sorry, Judge.
Hello?
This is difficult to do 2 hearings at once. Sorry, Judge, can you hear me?
Yeah, you ready for me now?
I'm kind of in the, can you give me 2 seconds?
Call me back.
All right, I will.
I'll put you on. I'll mute you up, okay? Let me know when you're ready.
Judge, I'm ready.
All right. Let me find your file now. 107. All right. We are on the record.
Judge, I think you muted yourself.
We are on the record on file number 2114017. This case is entitled General Linen Supply Company versus El Palenque Mexican Restaurant. This matter is set for pretrial today at 10 o'clock by a notice dated March 29th, 2021. It's now 10:39. I have only appearance from counsel for the defendant. Sir, could I have your appearance?
Good morning, Your Honor. Ryan Hill, P68445 on behalf of the defendant.
Yeah, Mr. Hill, I don't have the plaintiff in this matter. Looking at my file, we sent him the same notice that brought you here today. The notice was sent to the plaintiff's counsel at the 838 West Long Lake Road, Suite 100 in Bloomfield Hills, which is the address on his answer. The plaintiff has failed to appear. No good cause for that failure having been shown. The matter is dismissed without prejudice. We'll send out an order.
Thank you. Is that Carrie behind you? Hi, Carrie.
No, Carrie's, I'm in my chamber. She's in the courtroom.
Oh, I saw her in the courtroom. Just tell her I said, hey, Judge, I miss you guys.
Yeah, we're not going to do human contact. I think we're kind of past that for now, at least for this year. So
I'm sorry?
I think we're going to be out. Everything's going to be remote at least this year.
Yeah, I know.
Next year, it's, this job was isolating enough, right?
I know.
I know. Television screen.
I appreciate it. Thank you so much.
Okay, have a good day. We're off the record. All right. Let's see what we have here. All right, Ms. McQueen.
Yes.
Here on 539.
Yes.
Is there anybody here on Security Credit Service versus Donita McQueen?
I am, Your Honor.
Okay, then we have a pair. Mr. Bedouin, you off to my waiting room. And let's call your file. We are on the record calling case number 201-56539, Security Credit Services versus Donita McQueen. This is the adjourned date for a motion for summary disposition filed on behalf of the plaintiff in this matter. May I have your respective appearances?
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
And I'm Donita McQueen.
All right, Ms. McQueen, we were last together on this file on April the 9th, and we were scheduled to go forward on the motion for summary disposition, and you indicated you had not filed an answer.
Correct.
You indicated that you had not received the pleading, so we adjourned it to today's date.
Correct.
Did you file an answer?
Yes, sir.
When did you file it?
I overnighted it to on the 22nd.
Do you have it, Mr. Johnson?
We did receive it, Your Honor, yes.
Well, both of you are ahead of me because I don't have it.
Yeah, I sent a copy to you as well as to the attorney.
Okay, let me do this. Let me see if I can have my clerk check down on the ground floor to see if I have it, because looking at the register of action, and that's just a log of what happens in the court, the last action, I just had this register printed. The last action here is the April 9th motion scheduling. So you overnighted that. Tell me again, Ms. McQueen.
Overnighted it on the 22nd.
22nd?
Yes.
Okay, let me put you guys back in the waiting room, and then I'll see if I can figure out a way to see if we got it downstairs.
Okay.
Hello?
Carrie?
Yeah, I was calling you.
Yeah, what's up?
Well, the same thing, I'm hearing what you said. So overnighted, do you know what, did she attention the envelope to like civil or just to
She
36?
said to us. She said she sent a copy to the judge. I don't know.
Because they're gonna ask me that.
Okay.
And then what's that case number?
The case number is 20156-539.
And what is this for? It's a motion or something?
It should be an answer to a motion for summary disposition. And it would have been overnight, okay?
Okay, I'll try and see if they need to know if it's who it was addressed to, but I'll try. Okay, thank you.
All right.
Morning, Judge.
Good morning. Mr. Bedouin, you're here for what file?
Total Care versus Sharon Powell.
Okay. And Mr. Green, you're here for New Horizon versus City of Detroit?
Yes, Judge.
Okay, well, here's what we got. I got Ms. Oulette, and you're here on that case?
Yes, Your Honor.
Okay, so let's do yours. Let's put Mr. Bedouin in the waiting room, and we'll see if we can kill a file today. Okay, this is case number 2015830. This case is entitled Total Healthcare versus wrong case. I'm sorry, excuse me. I read the wrong case and case number. This is 2015830, Total Healthcare versus Sharon Powell. That can't be right.
That's
You
not
guys
correct.
say Detroit. I got your wrong case.
New Horizon.
Yep, my bad. Let's try it again this time to see if we can't get the case right. How about 2016699, New Horizon Chiropractic versus City Detroit? Is that better?
Good morning. Good morning, Your Honor. Kevin Green appearing on behalf of plaintiff.
Bar number?
67515.
Ms. Oulette?
Good morning, Your Honor. Teresa Oulette, P72765, appearing on behalf of defendant City of Detroit.
Okay. Two issues. First, I want to make sure that the 2.302A disclosures have been made.
They have, Your Honor.
And how about you, Ms. Oulette?
Well, let me look, Your Honor. Yes, Your Honor.
Okay, so you need to have these other disclosures. When
Yes,
we
Your
were last together on March 23rd, you guys were going to submit a stipulated order striking those claims that were barred by the 1-year back rule. I didn't get that order.
Yes, Your Honor. They submitted an order to me. I think we have a disagreement in the dates due to, they've added an additional 102 days due to the governor's prior executive order, which when I read that order and interpreted it, it appears that the dates are not told after June 20th of 2020, and they didn't file their matter until October 7th of 2020. So under my interpretation, the tolling would go back to October 7th of 2019. They are interpreting it as the tolling would go back to June 27th of 2019.
All right, so we're going to have a vote.
Yeah.
Since you guys can't agree on that, and I'll have to make the decision. One thing I would just say off the top of my head, the administrative order, as I recall it, and I don't have it in front of me, speaks to the commencement of an action. There's case law which seems to differentiate between the statute of limitations function in the statute and the 1-year back rule, calling the 1-year back rule a limitation on the amount of recovery rather than a statute of limitations. So just something I seem to recall the last time I looked at this question, but I'm not prejudging the case. So how long is it going to be before your motion for summary disposition can be filed?
I can file it within 2 weeks, Your Honor.
All right, then let's get you a date and get you out of here. We're not going to be able to accomplish anything until we know what we're fighting about.
Yes, Your Honor.
How about I give you guys a May 25 return date? Is that going to work for everybody?
What date? I'm
We
sorry?
do. Yeah, we can do May 25th.
May 25?
Oh, May 25. Oh, yes, Your Honor, I'm available.
Okay, so what I'll do is I'll calendar it just for pre-trial.
Okay.
You get your motion filed because Mr. Green has 3 weeks from the time the motion is filed to file his answer. And I don't know when that's exactly going to be, so it's kind of hard to time it out. This way we keep the matter on track and we figure out where we're going when we get to where we're going. But I just seem to recall having this issue before me about a month ago.
Okay.
But I'm not certain on that, but that's my recollection of what the case law is telling us. It's differentiating statute of limitations and the amount that can be recovered. And as I recall the administrative order, the language is commencement of actions. But I will see your respective orders, motions, May 25 at 11 o'clock. There's really nothing else we can accomplish today. Disclosures having been made. So we'll just figure out where we're going when I talk to you next.
Thank you, Judge.
Okay. Thank you for coming in. I'll send out an order, May 25 at 11. We'll try it again.
You and your staff have a great day.
All right, you guys be safe.
Yeah, you also.
All right, we are back on the record in file number 20156-539. The case is entitled Security Credit Services versus Donita McQueen. Folks, we are not going to be able to proceed today. I cannot locate Ms. McQueen's answer, yet counsel for plaintiff has it. So apparently everybody has it but me. But if it's mailed out overnighted on the 22nd, I think a short adjournment would be possible. We can get this done relatively soon. So I was wondering if I could have you guys come back on Thursday, May the 6th at 11 o'clock. Does that work for everybody? I don't want to just have you wait while we search and because even if I found Ms. McQueen's response, I'd have to have time to read it.
Right.
And it just doesn't seem fair.
Not that long.
Well, it just doesn't seem fair to have you wait. That's what I'm concerned.
The 6th works for me, Your Honor.
How about you, Ms. McQueen?
What time do you say? 11 o'clock the same
11
time?
o'clock like today,
Yeah, that's fine.
Okay, then what we'll do is we'll adjourn the motion to May 6th, 2021 at 11 a.m. And I'll send out an order and I'll talk to you guys both again, May 6th, 11 o'clock. Thank you for coming in.
All right. Thank you.
Have a good day.
You too.
You too.
All right.
It's not safe here. We are on the record calling file number 201588830, Total Healthcare versus Sharon Powell. We were last together on this file on March 23rd, 2021, at which time this matter was set for pretrial today, April 27th, 2012 at 11 o'clock, the time and date agreed to by both of the parties. Notice was sent to the parties on that March 23rd date. It is currently 11:33. I have an appearance from only one party, counsel for plaintiff. Sir, if I could have your appearance.
Good morning, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
I don't have a defendant here, sir. The default of the defendant who agreed to this date and time, who was given written notice and who failed to appear, no good call that failure having been shown. The defendant's default is hereby entered. This is a some certain case, sir?
Yes, Your Honor.
I look forward to your default judgment.
Thank you.
Thank you, sir, for coming in. We're off the record, and that concludes the docket for today.